Keep on admitting. Take the machine. Take the entire machine. Make sure it's not disconnected. Put your chair there. Put your seat on that side. Carry on. Sorry.
Yes, Your Honor, we are seeking to hold the two respondents before court.
We'll do this. Sorry, just a minute. Get out of that system. Just log out. Just shut it down. Leave the red button. Okay, that's it. Sorry, it's 10 calendar days, eh?
10 calendar days, Your Honor.
Yes.
So that you can be able to. And the second prayer is that we are seeking to have subjected to forensic examination to inform further investigations as well. Your Honor, we affidavits accompanying the application, where we now proceed, Your Honor, to demonstrate why it is our considered view that there are compelling reasons for the court to curtail the liberties of the two respondents beyond the 24 hours as per the Constitution. Finally, Your Honor, at the very outset, we wish on the reasoning in the authority of Titus Ngamau, that is Republic versus Titus Ngamau, 2014 Electronic Kenya Law Reports, which at page 3 as to what will about 10 of them, Your Honor, and indeed our application falls within the four corners of these compelling reasons. You know, firstly, the nature of the charges that are presented before the court as against their are serious in nature. Against organized crimes does classify any offense punishable for a period over 4 years. Your Honor, Kenya did ratify this convention and we have since domesticated the same. Your Honor, by virtue of Article 2 sub-Article 5, do form part of our laws. Investigations are still at an advanced, but thus far, the evidence that and specialized investigative techniques Your Honor, that evidence is not tenuous.
Meaning we have heavy, weighty evidence?
Yes, that is. And as such, the court should look into this in as far as considering bail and bond at this stage is concerned.
At the stage where he's not charged, isn't it?
Yes, where he's not yet charged. And where we say we need time to finalize these advanced investigations. And in fact, package the evidence that was package this evidence in a manner that will be palatable before a court of law. You know, the complexity of these offenses, of wildlife crimes, again demands of the investigators,
So,
requires that the investigators what was recovered to enable them further unravel this will include with the International Police Organization, Interpol, as well as other law enforcement agencies looking into financially related crimes. Pokamba, Your Honor. Exercise cannot humanly 2 hours as allowed in law, as there's need to cross-check that the investigators already have what is beyond our borders here. Article 28 of the Palermo Convention does in as far as forensically is concerned, including financial evidence. In as far as an analysis of evidence is concerned, wherever there are serious crimes that have been committed. Your Honor, the other ground that you do wish to rely on the respondents will willingly avail themselves to trial. And this, Your Honor, speaks to the antecedents, the issue as to whether the respondents will willingly avail them should they be released at this stage. To look into the antecedents of the respondents prior to this arrest. In Republic versus Mwema Mutia, that is criminal case number 11 of 2017, Republic versus Mwema Mutia.
So JKIA, sorry?
So I just have the citation, that is case number 11 of 2017.
You have a copy for me?
Yes, I have a copy, Your Honor.
Thanks.
Yes, which will supply shortly and also to the defense counsel. Your Honor, the judge, Professor Justice Joel Ngugi, did consider the antecedents of the accused person then. He actually fled from jurisdiction of the offense. Your Honor, we wish further to refer this to a further authority where the court cited flight risk as being Your Honor, this was in criminal revision, Mombasa High Court criminal revision.
As a major.
This was a Mombasa High Court criminal revision, number 166 of
2015.
2015.
The parties?
That is where Republic versus Feisal Mohamed and some 7 others, I believe. This being the first respondent before court. And Your Honor, at page 2 of that authority, Justice Moya did agree with the DPP on the application for revision of bond on the grounds that the first respondent now before court was a subject of an Interpol red notice and had in fact absconded the court's jurisdiction.
Mr. Mulamba, is he currently out of Interpol?
No, I'm speaking of the antecedents that were prevailing there.
Okay.
Because previous conduct on this person. You're at the Mombasa Law Courts. Your Honor, that position was further reiterated. The Court of Appeal, still at Mombasa, being Feisal Mohamed Ali versus Republic, 2015. That court again, the judges of appeal unanimously agree that in fact proved that one is a flight risk, then bond ought not to be granted. And therefore, Your Honor, we are saying, going by the past conduct of the accused person, the respondent, first respondent, over similar offences, he will take flight.
On similar,
the matters before the Mombasa Law Court,
on
similar accusations. Of trafficking.
Both of them are flight risks.
Yes. And going was committed in concert. It's an offence by both respondents, and therefore it follows that none of them would want to present themselves before court. Will note that there was 1 minute or so that
I took away.
Yes,
okay,
yes,
so
yes.
all right, I return it to you.
Thank you. So, as I one of our major witnesses, actually a star witness in this matter, to the respondents, and as we speak, Your Honor, we are engaging other government agencies with a view of ensuring that but Your Honor, our argument is that even if protection is available to us, that in itself is not a cure. Have as to his safety, not in
Is that a cure?
has, that is regard to the apprehension that he has, should they testify before court. And therefore it is our this stage, and even during trial.
Mr. Mulamba, have you not gone further? Let us first.
Very well. Bond should not be until there are measures put in place to ensure the safety of the witness.
That you can do in 10 days.
Sorry?
That you will do in 10 days.
No, yeah, it's a process, because even still, even if you were to make that application and you are allowed, witness protection in itself is not an answer to such reservations that the witness may have. Yes. Your Honor, witness interference can continue even after protective measures have been put in place. Itself is not an answer. And therefore we are saying, in their mind that their testimony will be key to be convicted. And therefore bond should be denied at this stage or at any other stage based on the issue of witness protection. Going by the totality thus far demonstrated, which is in line with section 36A of the CPC, that we have probable charges in mind, being those of trafficking. We have told this court what we have so far done, and as far as investigations are concerned. And what we intend to do within these 10 days. We therefore, the honor of the view that we have met the conditions laid out in as far as curtailing their rights are concerned. That is right to liberty. But to allow our application on a balance of probabilities, so far that Kokombao and his team are working on, going by the intel which we want to. These 10 days we see at the first instance is the least restrictive measure available to the investigator. No investigator will want to let go these two respondents at this stage. Least restrictive measure available to us. We therefore humbly pray.
Before you sit, Mr. Mlama, just a minute, Mr. Yes. Mr. Mlama, there is a paragraph there that I read it yesterday. I refer you. Madam. Can you please address me on paragraph 10?
Okay. Okay. Your Honor, this paragraph 10
yes.
Essentially is the case that gave
1098 of last year. They say that he absconded. What is that about?
The 2014 matter. It is the same case that I had referred to, okay. Which went over.
Okay, so let me see the reference in paragraph is a typo.
It's a typo, yeah.
I should refer to the 2014 case.
1098 of 2014.
It's a mistake. All right. Allow me just to put some things in order. I saw Mr. Excuse me, madam. Tell them I'm sorry, but what I'm seeing, they can just meet with their clients. I'll be ready for them at 11. Okay? All right. Ms. Kadani, you're ready? Don't sit the way you're sat. So thank you for listening. Most people interrupt all the time. So I hope the prosecution will allow you to. The other one doesn't want to tell you anything?
It's fine.
Also, as you submit, I wish that you would tell me their ages. Just for the record, it's absolute, just their ages.
The first respondent is 58.
your submissions, you can tell me about any health challenges they have. You understand why?
Yes, I do, please.
A58, and the other one is? That's important for me to know. Any health challenges that you know? Or you will submit at the end?
I will.
Okay. It's my time. Now
Yes,
I give you yours.
Thank you very much, Your Honor. And I'll take. No, I have the opportunity to rebut anything that they do say, and that the state has put main grounds that the state has put to you.
As compelling reasons?
Yes, they are compelling reasons.
According to them?
According to them.
Yeah, we have to say that.
Why the respondent on board, or any such terms as the court may be. The first is I have not had the benefit of seeing the authority that the nature of the crimes are serious. I also put it to this court that even the crime of murder is very serious. If you see the affidavit that they have put before you, they have said that the crimes warrant the respondents being imprisoned for a term of 7 years. Incentive.
The penal section gives a term of
Yes. I would like the court to consider the case of Sudi Oscar Kichu.
Mr. Mlam, I'm waiting for yours.
Yeah, I've handed over to Msula.
Republic.
A decision by Justice Kubi, correct?
By the now Court of Appeal. Within it, the court, when considering applications of this nature,
To put to the court in applications of this nature.
yes, is that the state must persuade the court that it is acting
Absolute.
a charge being preferred so let's with absolute good faith say half lies, so let me say half truths. You have been told.
Just refer me to the paragraphs.
Yes. I'm referring to the paragraphs.
Because I'm not able to read, just to the...
I will refer.
Okay.
So, paragraph 11. The first respondent had been previously convicted and sentenced to 20 years imprisonment and a fine of 20 million. A significant deterrent for the respondents to abscond from court. The first respondent was acquitted. The charges were quashed. There was a conviction.
could quash, did they quash everything? Quash the
Everything.
sentence and the
Everything.
refer and state that and state the first respondent
Was convicted in the magistrate's court. That conviction
the High Court.
and the sentence, yes,
The
was
High Court.
quashed by the High Court. So, as we speak about these antecedents, it must be clear the first respondent is not convicted, but for the sake they chose to leave.
Please submit.
You have also been told about an intern that my client, the first respondent, that is the name of the international warrants.
No, we clarified that it was.
Yes.
It's not now. I asked about. It is not for this matter.
It is not for this matter. The first respondent. The affidavit is as bare as they come. You have also been told that there is weighty evidence in the second respondent. You will note the majority of the submissions made by the state on past record before you that would allow you to you will see at paragraph affidavit, he apprehended the first and second respondent following a lengthy surveillance. They've had plenty of time to gather this so-called weighty evidence to arrest the respondents and charge them. Your Honor, will willingly avail themselves to court. Your Honor, I have not had circumstances, right? Has put it on record in the matter referred to by my learned colleague, not in fact tracked to Tanzania because he was summoned in the previous matter that my colleague referred you to, the previous criminal case, that he's not ever absconded the jurisdiction of the court because there's a warrant of arrest. That has never been the case. So, that are unproved, conviction that was quashed,
Sorry.
quashed,
Conviction and sentence quashed.
yes,
Mhm.
and of conduct that they are yet to this court. My clients, the first respondent is 58 years old. Ordinarily resident in Mombasa.
Just a minute, slow down. From his home and family.
Yes. He was bundled from Mombasa to Nairobi without any opportunity to even seek out the medication that he requires to keep up with his chronic condition.
How much water you?
Secondly,
How much?
a minute. The second respondent, as I said, is 75. And even if Your Honor was persuaded that the first respondent is as villainous as he has been painted today,
Article 50, sabbatical 2A remains always standard.
yes, innocent until proven guilty.
So even if I was persuaded, but I was just saying that I veer towards that side.
I'm happy you retain the 50 sub 2, but in conclusion, the nature of how the respondents have been presented to this court including the room full of media that knew he was already here long before even his family knew about it. It is our submission that the first and second respondents or rather, the state has not demonstrated to you, sorry, Your Honor, by any of the tests they have cited, that for on terms that this court can specify, and there are several. They can leave their passports, they can be required to present themselves before the officers or the police station.
Just a minute, i.e. deposit passports, regular check-in with the police.
Yes. And an order of no contact with any witnesses. And finally, what's to say that any of the processes that the state has said they need to undertake cannot be done while the respondents are out on bond? DNA forensics on the tasks, by all means, they are not being carried by the respondents. If they want to do the cyber forensics, by all means, they have the phones and the SIM cards. So there is nothing compelling that's been put before you that would warrant a denial of a constitutional right, especially to the respondents, considering the nature of their medical conditions, as in the case of the first respondent, and their age. Where are they going? And I would like to close with that, unless Your Honor has any questions for me.
I asked the questions I had in the beginning, thank you.
Obliged.
Mr. Mlam,
Yes, Your Honor.
according to my clock here, it is 9:48. You asked for 7 minutes, meaning 9:55.
That is fine.
You finish.
Then I'll just say my brief rejoinder. Firstly, to distinguish, Your Honor, set apart this case from the Oscar Sweden case that has been mentioned by counsel to do with good faith, Your Honor.
Just a minute. Unataka kuongea na wakili ama? Unajua utangoja kidogo, wacha tumalize na wakili.
I don't think he understands. It's about his ID. So I think that's something.
No, give you a chance.
Okay.
Let him feel the essence of coming to court is fully hearing.
Yes.
Mr. Mlama, please. We wish to set us distinguish.
Yeah, distinguish the Oscar Sweden case from the one before court. Ground that has been alluded to as to good faith. Your Honor, at paragraph 20 of our affidavit, we did in fact specify to bring the respondents back to court earlier than the 10 days should we be allowed. Then we definitely bring them before this court. Your Honor, there can be a no show of good cause than this one from the investigating officer. Secondly, still with that case, the least restrictive measure available to the state when faced with such circumstances. Your Honor, it is our humble view that going by the evidence thus far gathered is yet to be analyzed and converted into evidence before court. The only least restrictive measure that the investigators have circumstances is to come with an application under section 36A of the CPC, which gives life to the provisions of 49(1)(g) once we present suspects before court. Your Honor, we still reiterate on the seriousness of Article 2 of the Palermo Convention. We did not those that Kenya is signatory to.
Just a minute. Seriousness of the point.
It's Article 2 of the Palermo Convention that actually delimits such an offense as being a serious offense. Then, of course, we do not have the arrest warrant that was effected way back in 2014 for the civil, but it is a fact that the co-accused for the first respondent in 2014 took plea on the 11th, being brought in by the Tanzanian officials, Interpol officials. That is, and Your Honor, that is an antecedent we cannot ignore. Your Honor, the ordinary meaning, the ordinary English meaning of an antecedent our courts of law and indeed the courts to look into antecedents of suspects who are brought before them. This is one that you cannot ignore. Your Honor, it has been said that we have had sufficient time to prepare the case for plea. But Your Honor, will note that in our affidavit, we are stating that there were hours upon hours of surveillance. Surveillance is a special investigative technique, and there has to be other processes to turn this into evidence before court, and this is what we are asking.
There has to be processes.
There has to be processes, legal processes, to convert this evidence that has been obtained from the intelligence fence into what can be palatable before a court of law. Your Honor, the issues of the first respondent being sickly were in fact addressed at length by the two Mombasa superior courts in Mombasa, where he claimed the same, and the court also reviewed that the state should facilitate him accessing medical facilities. And we believe that should be the position at the moment.
The
superior courts in Mombasa, both the High Court and the Court of Appeal,
held
did deal with that issue and were of the view that the state can be able to facilitate access to medical attention. Your Honor, as for the provisions of Article 57 with regard to this constitution applies equally to all persons. And in fact, when counsel says that the accused persons, or rather the respondents, have not been treated with dignity, Your Honor, that is not the case.
I didn't record that. You said that? Did you say that?
I never did.
Yes, there was some issue that
they were bundled up.
They were bundled, yes.
A reference was.
And you see, they were bundled. And you see, bundled connotes a very undignified way of treating a suspect. In fact, they were arrested at 12 noon, and in a dignified manner, as per Article 57, they were flown to Nairobi. They were never bundled.
Ms. Galan, just for your information, I've never had anybody flown to Nairobi.
On government money.
In my time of being here. I'm just telling you. That is a new precedent. They say precedent? Precedent to me. The respondents were arrested at
1200 hours in Mombasa.
And flown.
And they flew to Nairobi at 1900 hours.
Which demonstrates?
This demonstrates that the state treated them with some dignity. And therefore it cannot be said that now we bundled them and handled them before court. As for the Fourth Estate, Your Honor, we know their rights under Article 34. I don't want to belabor that because they are not the ones in trial here. Your Honor, as I finalize in 1 minute, Article 25. Again, Article 25 of the Constitution.
Just a moment, let me find it. Yes.
Yes, Your Honor, Article 25 of the Constitution stipulates those rights which cannot be derogated from. Your Honor, certainly the right to liberty is one thing that can be limited as per Article 49(1) of the Constitution and Section 36A of the CPC. And it is this limitation that we come to ask this court to enforce, going by the evidence and the seriousness of the offense before that we intend to charge the respondents before court. Lastly, we do reiterate that in as far as there's a witness out there who is apprehensive of their well-being should the respondents be released, that in itself calls for restrictive measures to be employed or deployed by this court. Measures that will not inconvenience that particular witness any further than is necessary. Because you're saying even witness protection in itself has been described by scholars as social death. It's a social death. We therefore don't want to use it as an answer to the already well-founded apprehensions that this witness has. We don't want to use witness protection as the sole answer. It can never be the sole answer to the apprehension that this witness has should the respondents be released by this court. This apprehension continues throughout the trial should we get there. And therefore at this stage, we urge this court to limit their right to enable us to balance the rights of the victims and the witnesses, and of course their own rights. Your Honor, that is all. We therefore humbly pray that our application be allowed.
can have a chat with your client as we do housekeeping.
Your Honor, as I said, he was asking about his ID. I understand yesterday it was agreed that he would get it back.
Which court? It was not agreed before me. I don't know if there was a small chat somewhere.
Perhaps maybe there was a chat with the IO.
This is the only court I know. This one, I don't know what. Miss Mabama, as they sort that out, do you have anything you wish to say for the record?
No, I align myself with submission of counsel at this moment. Thank you.
Okay. I don't know whether I need to write the issue about the ID. What is the position?
We don't need to get there because these are very preliminary stage. If there was some agreement or some talk somewhere that council is aware of, that one can be handled. We don't need to bring this to this.
Okay, but it's now you see he's about to stand, so I need to address it. So now let's address it. He's asking for his ID. I need a response. I thought you could finish. So since we can't finish it, let me put it on the record. Okay, my client is asking Ms. Gadoni, first respondent only or both?
Both respondents. Sorry, I think the prosecution wanted to say something.
Okay. So am I putting it, because now I wanted this not to have to come here, but if
can we be off the record temporarily? Is it okay if he gets his ID?
No, so now you can ask them loudly like that when I'm
right.
here. You have to wait, I exit myself, I remove myself from the proceedings,
But
then now you can talk. So let me give direction as to what we are going to do.
Right.
Thank you.
I'm so sorry, unfortunately.
Let me just finish mine. You know my thoughts must flow.
Okay.
Let my thoughts flow.
Yes.
Then I
will address.
We can't start to have fight about this. There are so many other things that are really, you must choose your battles. In my life, I choose mine. So let's choose our battles. So let me finish. Then now I see whether this is something. Save your energy for the war, not this war.
Fair enough.
All right. In view of the lengthy submissions made, the court will need to retire to write a ruling. The court is alive to the time-sensitive nature of the matter The ruling will be delivered on the 29th of August, that's tomorrow at 9 a.m. I will come to court. Must be here. You can choose where you'll be, but I would suggest maybe we all be here. It's easier. The court has scheduled prison visits tomorrow and will proceed to conduct them after the delivery of the ruling. So I'm going to come in. I wasn't planning to come in. I will come in, deliver the ruling, and then proceed to the prison visits, okay? They are already aware we send them notices. The first and second respondents to be detained at JKIA Police Station, ruling on 29th of August at 9 a.m. Now let us come to other things. I need to take a break shortly. Are we agreed as to where we are in this? Or can we deal with it tomorrow? Can I give you, sorry, just have a seat. So you know they are teaching us to have mediation, arbitration, have good hearts. Sometimes things mellow with time. Can I give you 24 hours to see if you can agree? Then tomorrow we can deal with the issue of the ID. Let's see. Yeah, open your heart a little bit. Just give them some breathing space. And also, you please don't be so hard. Please just listen to what the cry she has on behalf of our client. If it's not resolved tomorrow, I will deal with it tomorrow.
Most obliged.
In 5 minutes, because I'm going to prison. Please, tomorrow, now, all right? Don't be so hard on them.
No. It's you see, my client came to me almost 3 times over that
one single issue.
Because without it,
I understand.
There's not much he can do.
It's not
himself.
A lot of them come like that, and they are amenable. Yes. Okay, so that's why I'm saying, please conserve your energy for what you need. Yes. Okay, if he has medication, if he needs to access all kinds of things. We live in this country, we know that without an identity card it's quite hard. Yeah. So now I wish to have 5 minutes to just regroup myself. Mr. Mlama, Mr. Chitama, one of you needs to come here, if Ms. Rono is not here, to deal with my small matters so that at 11 o'clock prompt we can start. So how much time shall I give so that we can be together? I also need them to exit. I mean, you are free to stay, but I'm sure that you're not going. Really, it's not me you came to see, no? Yeah, it's true.
When you're ready, you can start with the mentions.
Okay. So let's give them time to exit and to do what they need to do. Miss, as you were saying, yes, we didn't call them, okay? The matter was on the news yesterday. We all live in this country, we watch news.
Well, you know the issues that have been ongoing recently, so we are kind of seeing it as their way to clean up shop.
Oh, no, me, I don't involve myself in those things.
No, of course, we don't blame the court. It's off the record. It's not meant to.
All right. So I will give myself 10 minutes to allow them to do what they need to do.
Yes.
Thank you for coming. We wish you well. If you're coming tomorrow, please, you need to set up at least by 8:30. Those of you who came late, try and come a little bit early. It helps. So be here if you intend to come. The court we have guidelines there. Please set up by 8:30. I will deliver at 9. I have 10 minutes and then I'm coming back. Thank you. Mr. Sergeant Corporal Kimani, leta watu wengine wetu, except wale wa ile kesi ya Satan. Thank you.
Most obliged, Your Honor. Thank you for your time. Good day.
So, yeah.